There is a dangerous misconception common among junior developers and engineers: the belief that if you write the code or design the CAD model, you automatically own it and have the right to reuse it. In a professional environment, physical or digital effort does not grant you ownership. Control over a digital asset is dictated by strict legal boundaries and contracts. Misunderstanding these licensing agreements carries massive financial weight. A U.S. coffee company purchased the rights to use the Grumpy Cat image exclusively for an iced drink called Grumpyccino. When they applied the trademark to roasted coffee beans and other merchandise, they were sued for $710,000. Outright stealing intellectual property is even more costly. In 1978, 20th Century Fox sued Universal Studios, claiming the Battlestar Galactica television show stole 34 distinct ideas from the original Star Wars film, including specific vehicle designs and character names. In the Philippines, the frameworks governing these disputes are codified in two specific laws: the Intellectual Property Code, known as RA 8293, and the Electronic Commerce Act, or RA 8792. Navigating the intersection of these laws protects a high-value engineering career from the reality of career-ending legal liability. Under RA 8293, copyright protection protects original creations of the mind from the exact moment of creation. That protection lasts for the entire lifetime of the author, plus another 50 years after their death. This creates an immediate practical dilemma in the workplace. If an employee designs a complete 5-story building during their employment, who legally owns that copyright? The answer is found in Section 178.3 of the IP Code, the legal mechanism used to resolve workplace ownership disputes. The law provides two pathways. First, if the creation is a result of the employee's regularly assigned duties, the copyright automatically belongs to the employer. Second, if the creation is not part of their regular duties, the employee retains full ownership. This holds true even if the employee uses the employer's time, facilities, and materials to build it. Corporate IP ownership is dictated strictly by written job descriptions, not by who owns the computers. Violating these ownership boundaries is classified as infringement. You do not have to be the one who copied the file to be held liable. Aiding, abetting, or possessing an unauthorized copy for trade constitutes a crime. Consider the 1990 legal dispute over Ice Ice Baby. Vanilla Ice sampled the bass line from Under Pressure without securing a license or consent. He slightly altered the bass line's rhythm, operating under the assumption that a minor technical change would circumvent royalty laws and the need for permission. Altering a digital sample does not erase original copyright ownership. This resulted in Vanilla Ice paying a massive out-of-court settlement to the original creators. There is only one narrow set of legal defenses against infringement, outlined in Rule 14 of the IP Code, commonly known as fair use. If a user uploads a full copyrighted song to Facebook, they might claim they aren't making money off it, hoping fair use protects them. This legal defense almost certainly does not apply. Rule 14 requires adherence to specific conditions. Use must be strictly for charitable purposes. There must be no admission fee, absolutely no profit motive involved, and zero compensation paid to performers. Fair use is a highly restrictive defense for charities and schools. It offers zero immunity for developers casually scraping data or sharing digital assets online. While copyright protects creations of the mind, trademarks act as specific source identifiers. A trademark is a word, sign, or logo that differentiates one entity's goods from those of others.
Unlike copyright, which expires 50 years after the author's death, a trademark has a unique lifespan. It is granted for a 10-year period, but can be renewed and protected in perpetuity. If an owner stops monitoring their brand, they risk a process called genericide. This happens when a brand name is absorbed into common language as a generic term, completely invalidating its legal protection. Highly specific corporate trademarks must constantly fight to avoid becoming everyday words. An adhesive bandage is not legally a Band-Aid. Inflated cushioning is not bubble wrap. A sticky note is not a Post-it. This strict necessity to maintain control explains the Grumpy Cat Limited versus Grenade lawsuit. Grenade only purchased trademark rights to sell the iced Grumpyccino. By putting the Grumpy Cat trademark on roasted coffee beans and other merchandise, they illegally exceeded their contract. Copyrights sit quietly, protecting your work, but trademarks are fragile, high-maintenance assets that require continuous use and hyper-specific contract boundaries to survive legally. Once intellectual property is owned, it must be transacted. The process of legally moving these assets over digital networks is governed by the Electronic Commerce Act, or RA 8792. The Act establishes a foundational mandate. An electronic data message holds the exact same legal weight as a physical document. Furthermore, an electronic signature legally authenticates these documents, completely stripping away the requirement for wet ink. This legal equivalence is the invisible bedrock that allows all modern business-to-business and business-to-consumer software platforms to function. Because the economy relies on this architecture, Section 33 of the Act outlines aggressive penal provisions designed to protect digital infrastructure. Hacking, unauthorized access, and network piracy of intellectual property are punishable by severe imprisonment and fines commensurate to the actual financial damage caused. Under RA 8792, the code engineer's right functions as legally binding contracts and heavily guarded digital vaults, backed by real-world penalties. These digital laws represent the modern codification of ancient moral principles and professional engineering ethics. In 1999, a structural engineer utilized a proprietary retaining wall system. He applied pre-calculated mathematical formulas provided by a vendor without verifying the math. Shortly after completion, the wall collapsed under heavy rain. The engineer failed his duty of care, the ethical expectation that professionals must exercise reasonable diligence. Using unverified mathematical data constituted severe professional negligence. In 1986, NASA management chose to ignore engineers' warnings about O-ring failures in cold temperatures. The Space Shuttle Challenger exploded mid-flight, showcasing the ultimate tragic consequence of discarding a duty of care. These physical engineering failures map directly to the responsibilities of modern digital engineers and software developers. Correlating that duty of care to digital creation means respecting the strict intellectual property boundaries of Section 178.3. The ethical requirement to verify structural mathematics is the same principle as the legal mandate to ensure the security of electronic data messages under RA 8792. Every technical decision an engineer makes, from executing an API call to verifying an electronic signature, carries profound ethical and legal weight. Professional tech practice requires treating laws like RA 8293 and RA 8792 as they were written, the non-negotiable ethical foundation of our digital infrastructure.